नमस्कार प्यारे विद्यार्थियों, आज बहुत बड़ा फैसला होने वाला है सुप्रीम कोर्ट का नीट को लेकर के। मैं हूं प्रताप राजपुरोहित और लाइव हम देखने वाले हैं सुप्रीम कोर्ट नीट को लेकर के क्या डिसीजन देने वाला है। लाखों विद्यार्थियों की, पेरेंट्स की, टीचर्स की निगाहें इस फैसले पर टिकी हुई है कि आज जो डिसीजन होगा उस पर तय करेगा कि भविष्य में डॉक्टर कौन बनने वाले हैं, कैसे लोग मेडिकल कॉलेज के अंदर जाने वाले हैं, कैसे आपका एडमिशन होने वाला है, अगर किसी तरह की गड़बड़ियां हुई है तो उन लोगों को क्या सजा होने वाली है। बहुत सारी चीजें हैं जो आज माननीय सुप्रीम कोर्ट के फैसले के बाद में डिसाइड होगा कि किस तरह से होने वाला है। तो चलिए आज का हमारा सेशन शुरू करते हैं। आज हम लाइव देखने वाले हैं कि सुप्रीम कोर्ट का जो फैसला नीट को लेकर के आने वाला है वो किस तरह से आने वाला है, क्या होने वाला है। जैसा कि आपको पता है कि पूरा का पूरा आज जो है 18 जुलाई को बड़ा फैसला आने वाला है। इससे पहले 11 जुलाई को फैसला आना था, लेकिन उसको एक्सटेंड करके 18 जुलाई कर दिया गया था। और बहुत सारे जो लोग हैं उनका कहना भी ये था कि बहुत अच्छा किया, ताकि जो भी इसमें एडवोकेट थे उनको समय मिल जाएगा कि भाई थोड़ा और उनको प्रैक्टिस हो जाएगी, ताकि किस तरह से उनको अपने सवाल जो पूछने हो जाएगा। आज जो भी नए विद्यार्थी जुड़ रहे हैं उनको मैं बता देता हूं कि है क्या पूरा का पूरा मामला क्या है। नेशनल टेस्टिंग एजेंसी जो है वो 5 मई को उसने क्या किया था, नीट का एग्जाम कराया था, नीट यूजी 2024 का एग्जाम कराया था। और परीक्षा में पेपर लीक को लेके और छात्रों को जो ग्रेस मार्क्स दिए गए थे उसको लेकर के बड़ा विवाद हुआ था कि भाई किस आधार पर दिए हैं, कैसे दिए हैं, बड़ी विवाद का विषय हुआ था। और उसके बाद में नेशनल टेस्टिंग एजेंसी ये करती क्या है भाई, जो ये नीट का एग्जाम है इसके माध्यम से होता क्या है। नीट के एग्जाम के माध्यम से देश भर के जितने भी सरकारी कॉलेज है, निजी कॉलेज है, MBBS है, BDS है, आयुष है और अन्य संबंधित पाठ्यक्रमों के लिए प्रवेश परीक्षा जो है उसी को हम नीट कहते हैं। और ये देश की बड़ी परीक्षा और बड़ी परीक्षा के अंदर जैसा कि आपको बताया कि 23 लाख से अधिक विद्यार्थियों ने इसमें फॉर्म भरा था और लाखों विद्यार्थियों ने जो परीक्षा दी। और मामला क्या है कि केंद्र सरकार और NTA दोनों ने माना है कि गड़बड़ तो हुआ है, दोनों ने यह स्पष्ट स्वीकार किया है कि मामला तो गड़बड़ हुआ है। लेकिन केंद्र सरकार और NTA दोनों का कहना है कि गड़बड़ी पैन इंडिया या पूरे पेपर में गड़बड़ी नहीं हुई है, ये उनका कहना है। कुछ सेंटर में थी तो सरकार का कहना है कि CBI पूरे मामले की जांच करी है, लोगों की गिरफ्तारी भी हो चुकी है। ये नीट को लेकर के पूरा का पूरा मामला है। आज उसकी सुनवाई होनी है और सुनवाई किस तरह से होने वाली है, नीट को लेकर के जो पूरा का पूरा सुप्रीम कोर्ट के अंदर फैसला आने वाला है, हम आपको बताने वाले हैं। 3 जजों की जो पीठ है CJI सहित वो आज फैसला करने वाली है। तो एक बार हम आपको ले चलते हैं कि लाइव शुरू हो गया है, तो हम आपको एक बार दिखा देते हैं कि क्या कैसा है दृश्य और क्या चल रहा है वहाँ पर। न जाने कितने विद्यार्थियों की निगाहें टिकी हुई है आज के इस फैसलों को लेकर के। थोड़ा समय लगेगा मुझे लग रहा है। 435 नंबर आज का जो है, जो नीट के मामले की सुनवाई का है, 435 नंबर है। और उसका यहाँ पर हम देख रहे हैं जो डिसीजन होने वाला है किस तरह से होने वाला है, पूरी की पूरी आज हम लाइव देखेंगे किस तरह से क्या फैसला आने वाला है। बहुत सारे ऐसे विद्यार्थी हैं जिनका कहना है कि री एग्ज़ाम होना चाहिए, वापस से एग्ज़ाम होना चाहिए। बहुत सारे विद्यार्थियों का कहना है नहीं होना चाहिए। बस अब फैसला सुप्रीम कोर्ट का जो होगा वो हम सब लोग स्वीकार करेंगे। जितनी भी याचिकाएं हैं सबकी सुनवाई आज होने वाली है। 40 से ज़्यादा याचिकाएं जो है सुप्रीम कोर्ट के अंदर लगी हुई है, उन सब की सुनवाई आज इस नीट के मामले को लेकर के होने वाली है। गुड मॉर्निंग सारे स्टूडेंट को, गुड मॉर्निंग। एक बार सब लोग अपने इस सेशन को शेयर कर दीजिए, जितने भी पेरेंट्स की, टीचर्स की, जितने भी स्टूडेंट की जो निगाहें हैं आज के फैसले को लेकर के, क्योंकि ये कोई छोटी बात नहीं है, बहुत बड़ी बात है। देश का इतना बड़ा जो एग्ज़ाम होता है जिसमें डॉक्टर बनते हैं, और बहुत सारे ऐसे पेरेंट्स और स्टूडेंट जो अभी सुप्रीम कोर्ट के बाहर खड़े हैं, उनमें से जो आक्रोशित लोग हैं वो ये कह भी रहे हैं कि भाई क्या MBBS जो मुन्ना भाई MBBS जैसे लोग हैं उन लोगों को मेडिकल कॉलेज में एडमिशन मिलेगा क्या, जो योग्य उम्मीदवार है उनको एडमिशन नहीं मिलेगा क्या। ये लेकर के ये जो बड़ा एक प्रश्न है और वास्तव में सही भी है। अगर किसी विद्यार्थी ने मेहनत की है, उसको उसकी सीट नहीं मिल रही है, उसके स्थान पर किसी गलत व्यक्ति को मिल रही है, तो ये एक जस्टिस नहीं है, अन्याय है। और अगर सारे जितनी भी याचिकाएं हैं उन सारी याचिकाओं को लेकर के आज फैसला आपका होने वाला है। थोड़ा समय लगेगा मुझे लग रहा है, लेकिन ज़्यादा समय नहीं लगेगा। अभी कुछ ही देर बाकी है जब ये फैसला जो है नीट को लेकर के आने वाला है। परीक्षा जो है, कुछ मुख्य मांग यहाँ पर क्या है कि परीक्षा रद्द हो, दोबारा से परीक्षा हो, धांधली की पूरी जांच हो। हाई कोर्ट में दाखिल जो याचिकाएं हैं उनको सुप्रीम कोर्ट में दाखिल की जाए, ऐसा भी NTA का कहना है। NTA की अर्जी की पूरी सुनवाई भी आज होगी। अभी माइक वगैरह की टेस्टिंग वगैरह हो रही है, किस तरह से क्या है पूरा का पूरा पुल चेक होता है, उसके बाद में शुरू होती है सुनवाई, जैसा कि आपको विदित है।
जल्दी हो गया सब कुछ।
जब तक शुरू होता है तब तक मैं एक बार आपको पुनः बता देता हूं कि पूरा मामला क्या है। जो 5 मई को एग्जाम हुआ था, नीट यूजी का जो एग्जाम हुआ था, उसको लेकर के कि जो कुछ पेपर है, पेपर लीक होने की जो घटनाएं कुछ स्थानों पर मिली थी, ग्रेस मार्क्स जो एनटीए ने दिए थे उस पर भी विवाद था। और ये एग्जाम होता है वो जो मेडिकल कॉलेज है, एमबीबीएस है, बीडीएस, आयुष और अन्य संबंधित पाठ्यक्रमों के लिए जो प्रवेश परीक्षा है उसके लिए। हालांकि केंद्र सरकार और एनटीए दोनों ने माना कि गड़बड़ी हुई है, लेकिन उनका कहना है कि बड़े लेवल पर नहीं हुई है। जबकि जो स्टूडेंट्स हैं, पेरेंट्स हैं, टीचर्स का कहना है कि अगर बड़े लेवल पर गड़बड़ी हुई है तो रीनीट होना चाहिए ताकि विद्यार्थियों के साथ न्याय हो सके। और मैं अगर बात करूं यहां पर तो नीट पेपर लीक में आज जो है सुप्रीम कोर्ट में सुनवाई अभी कुछ ही समय में होने वाली है। सीजे की अध्यक्षता वाले 3 जजों की जो बेंच है वो सुनवाई करने वाली है। 3 जजों की बेंच है। सुप्रीम कोर्ट के चीफ जस्टिस डीवाई चंद्रचूड़ सिंह जी की बेंच ने नीट यूजी परीक्षा के खिलाफ दायर अलग अलग याचिकाओं पर सुनवाई करना शुरू होने वाली है, अब कुछ ही देर में होने वाली है। और बड़े मुद्दे और ब्रॉडर पिटिशंस पे पहले चर्चा होगी। और आज जो पीठ है उसके अंदर मुख्य न्यायाधीश डीवाई चंद्रचूड़ जी, न्यायमूर्ति जेबी पारदीवाला जी और न्यायमूर्ति मनोज मिश्रा जी इसके अंदर शामिल है। और इस पूरे के पूरे मामले को लेकर के सुप्रीम कोर्ट की जो पहले 8 जुलाई को जो सुनवाई हुई थी उसमें सुप्रीम कोर्ट ने एनटीए को यह बताने का आदेश दिया था कि आपको बताना पड़ेगा, पूरी डिटेल बतानी पड़ेगी। और डिटेल क्या क्या बतानी है कि पेपर लीक कब हुआ है, प्रश्न पत्र लीक कैसे हुआ है, भाई हुआ तो वो कब हुआ था, पूरी जानकारी आपको देनी है। कैसे हुआ, कैसे, कौन से माध्यम से हुआ था, प्रश्न पत्र लीक होने से लेकर 5 मई को नीट यूजी परीक्षा के वास्तविक आयोजन के बीच में कितना समय रहता है, ये टाइम गैप कितना है, भाई इतना टाइम के अंदर कहां तक कितने लोगों तक पहुंचा था। शीर्ष अदालत ने केंद्र सरकार को अपने कार्यों का विवरण देते हुए हल्फनामा प्रस्तुत करने का निर्देश दिया था। नीट यूजी परीक्षा के संबंध में सीबीआई से स्थिति रिपोर्ट मांगी थी और अदालत ने परीक्षा से समझौता होने की बात भी स्वीकार की थी। उस समय जो 3 न्यायाधीशों की जो पीठ है उन्होंने जो डिसीजन दिया था वो क्या डिसीजन दिया था कि इसमें कोई संदेह नहीं है कि परीक्षा की पवित्रता से समझौता किया गया है। यह एक स्वीकृत तथ्य है कि लीक हुआ है और लीक की प्रकृति कुछ ऐसी है जिसका हम पता लगा रहे हैं। यदि यह व्यापक नहीं है तो इसे रद्द नहीं किया जा सकता, लेकिन दोबारा परीक्षा का आदेश देने से पहले हमें लीक की सीमा के बारे में सचेत होना चाहिए, क्योंकि हम 23 लाख छात्रों से निपट रहे हैं। 23 लाख छात्रों का सवाल है, कोई एक विद्यार्थी का नहीं है, कोई 2 विद्यार्थी का नहीं है, 23 लाख स्टूडेंट का सवाल है। तो अगर जरा भी कहीं गड़बड़ी हुई तो उसका पूरे की पूरी जांच पड़ताल होनी चाहिए। कोर्ट का कहना था 11 जुलाई को जो सुनवाई थी उसको हमने 18 जुलाई को जो आगे एक्सटेंड की गई थी। सीजेजी का कहना था कि लीक सोशल मीडिया के थ्रू हुआ है तो इसका स्कोप बहुत बढ़ जाता है। और उन्होंने अंग्रेजी में कहा था वाइल्ड फायर की तरह, ये जंगल के आग की तरह खबर फैल जाती है। तो अगर सोशल मीडिया के माध्यम से अगर लीक हुआ है तो बड़ा चिंता का विषय है, ये उनका कहना था। हालांकि उन्होंने ये अभी तक ये नहीं कहा है कि भी जो है वो फैसला आज आने वाला है। एनटीए की जो अर्जी है उसकी सुनवाई भी आज होने वाली है। इसके अलावा क्या अपडेट और रहता है, एक बार हम वापस से रुक कर लेते हैं। जहां पर लाइव चल रहा है वहां पर हम ले चलते हैं आपको। सीधा का सीधा हम देख रहे हैं जहां से आज सुप्रीम कोर्ट के अंदर जो सुनवाई होने वाली है। एनटीए जो है वो अभी भी यही मांग कर रहा है कि जितने भी कोर्ट है, सारे जितने की केस है वो सारे के सारे सुप्रीम कोर्ट के अंदर ट्रांसफ़र किए जाए। 11 जुलाई को जैसा कि आपको पता है जो सुनवाई होनी थी, हम भी आपसे साझा किए थे, लेकिन बट वो नेक्स्ट एक्सटेंड कर दी गई थी 18 जुलाई को, क्योंकि जो कुछ एडवोकेट जो है वो उस दिन उपलब्ध नहीं थे और भी बहुत सारे रीज़न थे इसकी वजह से। सुप्रीम कोर्ट में जो एनटी का हल्फनामा था कि अंकों का वितरण बिल्कुल सामान्य है, और याचिकाकर्ताओं का जवाब है कि 100 जो छात्र थे उनको, और बड़ी सवाल ये है कि जो 680 और 700 नंबर लाने वाले, इससे पहले जितने भी एग्जाम हुए हैं 680 और 700 नंबर लाने वाले विद्यार्थियों को उनको सरकारी कॉलेज मिल गए थे, है ना, बढ़िया कॉलेज जो मिल गए थे, एम्स कॉलेज मिल गए थे, लेकिन अभी इतने नंबर लाने के बाद में भी उन विद्यार्थियों का सिलेक्शन नहीं हो रहा है। ये भी बड़ा चिंता का विषय है। बहुत सारे मेरे साथी जो अभी जुड़े हुए मेरे साथ में सब कह रहे हैं री-नीट होना चाहिए, री-नीट होना चाहिए। प्यारे विद्यार्थियों, अब री-नीट होगा नहीं होगा, क्या होगा, इसमें तो माननीय सुप्रीम कोर्ट जो फैसला देगा उसको हम सहर्ष मंजूर करेंगे, और उम्मीद करते हैं कि विद्यार्थी जितने भी हैं, जो भी विद्यार्थी है, किसी भी विद्यार्थी के साथ गलत नहीं होना चाहिए, उनको न्याय मिलना चाहिए, वास्तविक जो हकदार है उनको उनकी कॉलेज मिलनी चाहिए, और जिन्होंने गलत तरीके से कुछ गड़बड़ी किया उन विद्यार्थियों को, और या जो पेरेंट्स या जो भी लोग इसमें इन्वॉल्व है, उनको सज़ा होनी चाहिए, और सज़ा का प्रावधान इतना होना चाहिए कि उनको कभी भी उस सपने में भी इस तरह का सोच नहीं सके। बहुत सारे राज्यों के अंदर अच्छा प्रावधान चल रहा है कि भाई कोई भी पेपर को लेकर के कोई गड़बड़ी करता है तो उनको कठोर सज़ा दी जाए। आप लोग जितने भी लाइव देख रहे हैं, आपका क्या कहना है? अगर कोई पेपर लीक करता हुआ पकड़ा जाता है, चाहे कोई विद्यार्थी हो, चाहे कोई पेरेंट्स हो, चाहे कोई भी हो, तो उनको कैसी सज़ा होनी चाहिए, आप कमेंट बॉक्स में लिख के मुझे बताओ, क्योंकि जब तक कठोर सज़ा नहीं होगी तब तक ये समाधान नहीं होने वाला है। और जो सीबीआई है वो भी पटना एम्स के जो 3 डॉक्टर हैं उनसे पूछताछ कर रही है। सीबीआई ने 9 घंटे तक लगातार पूछताछ की है, तो ये भी बड़ी अपडेट है। सीबीआई जो है वो 9 डॉक्टरों से, जो एम्स के जो डॉक्टर थे उनसे भी पूछताछ कर रही है कि अगर कहीं ना कहीं कोई गड़बड़ है तो उसकी पूरी जांच की जा रही है। अभी देखते हैं क्या रहता है, मुझे लग रहा है थोड़ा सा समय और लगेगा। अभी पूरी वो चेक कर रहे हैं कि भाई पूरा ऑडियो वीडियो सब क्वालिटी वगैरह सब सही आ रही है क्या। 625 पे 48 पे जनरल EWS में राजस्थान में गवर्नमेंट मिल जाएगा क्या? देखो प्यारे विद्यार्थी, अभी हम कुछ नहीं कह सकते हैं, काउंसलिंग स्टार्ट होगी उससे पहले अभी देखो क्या होता है, डिसीजन क्या आता है उस पर निर्भर करेगा, और जो और विद्यार्थी जिनके एग्ज़ाम हुए थे उनको लेकर के क्या रहता है, सारी चीज़ों को लेकर के उसके बाद में डिसीजन आए। हाँ बिल्कुल जस्टिस होना चाहिए, जो विद्यार्थी जिन्होंने बढ़िया से मेहनत की उनके साथ जस्टिस होना चाहिए। मैं एक बार फिर बता देता हूँ, जितने भी विद्यार्थी ये फैसला आया था, हम बात करते हैं कोर्ट ने एनटीए को कहा कि पूरी जानकारी हमको चाहिए। इससे पहले जो जितने भी जो नीट मामले को लेकर के जितना भी डिसीजन हुआ था उसमें कोर्ट ने कहा था कि प्रिंटिंग प्रेस कहाँ है ये आपको बताना पड़ेगा, हमें पूरी जानकारी देनी पड़ेगी। उनके पास डेटा कैसे आता है, बहुत सारे विद्यार्थी कह रहे हैं फांसी होनी चाहिए, शायद फांसी की सज़ा ही कम पड़ जाएगी। देखो ये बहुत बड़ा गलत है। एक विद्यार्थी कितनी शिद्दत से मेहनत करता है ना, उस विद्यार्थी, सिर्फ विद्यार्थी का नहीं है, उस विद्यार्थी के साथ जुड़े हुए टीचर्स जो है, उनके पेरेंट्स जो है ना, और जो उसको वेल विशर जो है, उसके दोस्त जो है, जो उसको मोटिवेट करते हैं कि नहीं भाई आज के ज़माने के अंदर ऐसा जो टेक्नोलॉजी का ज़माना है, इसके अंदर एक विद्यार्थी अगर अपने पढ़ने को लेकर के बड़ा एक्साइटेड है और बड़ी मेहनत करता है, जब उसके साथ न्याय नहीं होता है तो वास्तव में जो गुनहगार है उनको सज़ा होनी चाहिए और कठोर सज़ा होनी चाहिए। तो उनके पास डेटा कैसे आता है, एनटीए को कोर्ट ने कहा कि उनके पास प्रिंटिंग प्रेस आपकी कहाँ बताना होगा आपको, उनके पास डेटा कैसे आता है, एनटीए के पास पेपर वापस कैसे आता है, ट्रक से आता है, रेल से आता है, हवाई जहाज से आता है, ये सारी जानकारी देनी पड़ेगी आपको, बताना होगा, ताकि पता चले कि कहाँ गड़बड़ियों की संभावना और कैसे होती है, और पेपर वापस कहाँ रखा जाता है, क्या सारे एसओपीज फॉलो हो रहे हैं या नहीं हो रहे हैं। ये पूरा का पूरा कोर्ट ने पूछा था। किससे पूछा था? एनटीए से पूछा था। नीट एग्जाम बड़ा एग्जाम क्यों, जैसा कि हम बात कर रहे हैं, इतना बड़ा एग्जाम कैसे है, कौन से इस कारण है? तो नीट एग्जाम में रजिस्ट्रेशन 24,06,079 इतने रजिस्ट्रेशन हुए थे, और एग्जाम में 23,33,297 विद्यार्थी शामिल हुए थे जिन्होंने परीक्षा दी थी, और क्वालिफाई 13,16,268 विद्यार्थियों ने क्वालिफाई किया था। और नीट की काउंसलिंग जो है वो कैसे होती है, जैसा कि आपको विदित है, नहीं पता देख लीजिए, कॉलेज के नाम पहले लोग करने होते हैं, सीटों का फिर अलॉटमेंट होता है, अलॉटेड कॉलेज में फिर रिपोर्ट करना होता है, ये काउंसलिंग की प्रोसेस रहती है। अभी ये भी सवाल बच्चों का चल रहा है कि क्या फैसला आने से पहले क्या काउंसलिंग हमारी शुरू हो जाएगी या नहीं हो जाएगी, ये भी बड़ा सवाल है। पिछली जो सुनवाई है वो 11 जुलाई को हुई थी, आपको जैसा कि मालूम है, और अभी 18 जुलाई 11 जुलाई को कहा था कि भाई हम पूरी प्लानिंग के साथ में, हाँ जो सीजेई और उनकी जो पूरी पीठ है, उन्होंने ये भी कहा था कि भाई आपकी जो पूरी की पूरी रिपोर्ट है जो है वो कंसोलिडेट करके हमें देनी है, 10 पेज के अंदर कंसोलिडेट करके देना है, क्योंकि बहुत सारे मामले उन सब का एक साथ में, तो एक बना लीजिए कि भाई जैसे मान लो कि कॉमन दो लोगों की सेम ही प्रॉब्लम है, तो उन दोनों को एक साथ में करके देख दीजिए ताकि उसी के लिए समय वेस्ट ना हो। इसके अलावा रीनीट के बारे में एनटीए और केंद्र सरकार का क्या कहना है। एनटीए का कहना है कि 2 सेंटर, एक पटना और दूसरा गोधरा पर गड़बड़ी की बात सामने आई है और दोनों की सीबीआई जांच कर रही है। एनटीए कहना है कि लाखों बच्चों ने पेपर दिया था पूरी ईमानदारी के साथ, तो अगर री एग्जाम होगा तो उनके साथ में उचित नहीं होगा। और इसके अलावा एनटीए कहना कि ग्रेस मार्क्स किस आधार पर दिए गए, उस पर सवाल उठा, तो उन्होंने कहा बच्चों के दोबारा एग्जाम हमने ले लिया, तो अब पूरी परीक्षा के नतीजों को रद्द करना ठीक नहीं होगा। ये रीनीट के बारे में एनटीए और केंद्र सरकार का कहना है। तो ये पूरा मामला क्या है, ये पूरी जानकारी मैंने आपको बताई है। एक बार हम वापस से आपको ले चलते हैं जहां पर लाइव चल रहा है सुप्रीम कोर्ट का, वहां पर आपको ले चलते हैं। चलिए।
Can be subjected to when a plea of accord and satisfaction is taken by the defendant. And thirdly, what is the effect of the decision of this court in interplay between arbitration agreements under the Arbitration and Conciliation Act 1966 and the Indian Stamp Act 1899 on the scope of powers of the referral court under Section 11 of the Act 1996. Just quickly, what we have said is, thus, even if the contracting parties, in pursuance of a settlement, agree to discharge each other of any obligations arising under the contract, this does not ipso facto mean that the arbitration agreement too would come to an end unless the parties expressly agree to do the same. The intention of the parties in discharging a contract by accord and satisfaction is to relieve each other of the existing or any new obligations under the contract. Such a discharge of obligations under the substantive contract cannot be construed to mean that the parties also intended to relieve each other of their obligation to settle any dispute pertaining to the original contract through arbitration. Although ordinarily no arbitrable disputes may subsist after execution of a full and final settlement, yet any dispute pertaining to the full and final settlement itself, by necessary implication, being a dispute arising out of, or in relation to, or under the substantive contract, would not be precluded from reference to arbitration, as the arbitration agreement contained in the original contract continues to be in existence even after the parties have discharged the original contract by accord and satisfaction. Our final conclusion is like this. The existence of the arbitration agreement as contained in clause 13 of the insurance policy is not disputed by the appellant. The dispute raised by the claimant, being one of quantum and not of liability, prima facie falls within the scope of the arbitration agreement. The dispute regarding accord and satisfaction, as raised by the appellant, does not pertain to the existence of the arbitration agreement and can be adjudicated upon by the arbitral tribunal as a preliminary issue. For all the foregoing reasons, we uphold and affirm the appointment of Justice K. A. Pooch, former judge of the High Court of Gujarat, as an arbitrator to resolve the disputes between the parties. But what judgment is that we have clarified our earlier judgment in Ari. The clarification starts from para 126. We have explained how Ari should now be construed or understood, more particularly in light of this pronouncement. And what is important is, just one paragraph very quickly, we are running late. Thus, we clarify that while determining the issue of limitation and exercise of the powers under Section 11(6) of the Act 1996, The referral court should limit its inquiry to examining whether Section 11, subsection 6 application has been filed within the period of limitation of 3 years or not. The date of commencement of limitation period for this purpose shall have to be construed as per the decision in Arif Azim. As a natural corollary, it is clarified that the referral courts at the stage of deciding an application for appointment of arbitrator must not conduct an intricate evidentiary inquiry into the question whether the claims raised by the applicant are time barred and should leave that question for determination by the arbitrator. Such an approach gives true meaning to the legislative intention underlying Section 11 bracket 6 capital A of the Act and also to the view taken in Ray interplay. That's how we have decided. Thank you.
जैसा कि आपको पता है कि कोई भी फैसला होता है तो जो पीठ होती है वो आपस में डिस्कशन भी करती है, तो इसी तरह से डिस्कशन कर रहे हैं आपस में।
May I just give everybody else, please circulate emails, because once we breach the norm, then I cannot breach it only for seniors and I have to do that for everybody else. It completely destroys the system which I have put in place. Everyone who has a request, please send me an email. I'll look at it by the afternoon today.
No, this is not a listing request. It's not a listing.
Anybody who does not have a listing request, some correction in an order, something is free to mention.
If there's a fact coming tomorrow, we're asking the review today to be put with that tomorrow. That's a request.
That also has to go on an email. That's a listing.
I put it in the email.
Listing, if it's on listing, please don't mention. Please put it in an email. I'll look at it in the afternoon today. I promise you I'll do that. It's the same thing. When was the include order passed? By 19th, right? So we'll list it tomorrow.
Your Lordship, I'm just saying.
List it tomorrow. Okay, but you could have also sent it in an email. Sorry. Circulate a rejoinder.
Circulate a letter in tomorrow's matter listed at item 26 and for the responding to the please.
So late now. We'll see tomorrow.
Because I'm mentioning a matter where I've already sent emails to them. But I've also sent
It will be dealt with.
this morning was that meeting.
Sure, balance.
Just a query, would your lordship be taking the part third income tax matter or?
Just wait, I've just told the court master, we'll tell you in a minute, yes.
I'm sorry, there's one request. There's an order that your lordships had passed last week, my lord. It's an arbitration petition. Your lordship perhaps will recall, my lords, I had made a submission that the pendency or the reference to arbitration will not impact any criminal proceedings that we might initiate. Because our recollection is the lordships had dictated that in court, my lord, but it's perhaps not reflected in paragraph 3, my lord. No, but your lordship
We also said in the course of the discussion,
Please, my lord.
that an arbitration will never affect a criminal prosecution.
But I made that submission, I think.
All right,
Your
we'd
lordship
have to
had
put
made that
something, we'd have to put something, clarify something which is obvious.
Very good.
So before we begin, what we're proposing to do is that we have the income tax part third group NEET is above that today. We'll at least open the NEET matter and then we'll see what to do with the partnered group. We'll hopefully start with the partnered group, but it might just have to wait until we open the NEET matter because there's some urgency in the NEET matter. Children, young students all over the country are waiting for the outcome of this matter. So, but we are not going to lose season of the income tax matter because we are now also mentally we are in the matter.
But may I suggest, since we have circulated something yesterday, it can be kept tomorrow also.
Let's at least open the NEET matter today because let's see the matter.
The others can be discharged, etc. Many are procedural matters, item 4, etc.
So what we are doing is, procedure number 1, for instance, is about bifurcating. We'll take up item 1. So it's bifurcating matters, etc. That will pass procedural direction.
Police for compliance like that. When your lordship
Right. We just yes.
Item 1 is not bifurcating. Item 1 is a batch of cases on fringe benefit tax.
Yes, the fringe
benefit. Come on some of the name. Yes. The bifurcation is the gaming matter, I think, if I'm not mistaken.
Why is that listed for direction? Because item 1 is only this.
There are two appeals.
Right. The courtmaster says that we have to pass the usual procedural direction for appointing nodal counsel so that they prepare one common compilation. So tell us who will be the nodal counsel.
That's right. Mr. Cooper, I'll give my AR's name to your lordship's bench, and one from the department. So 2 of us can be there.
Is there a compilation for the department? Is there a compilation for the only petition? So now tell us for the petitioners who will be the nodal counsel.
I can volunteer. Mr. Kunal Kishore can.
And what? Since you've already prepared.
Anisha Karya have already our compilation.
And for the department, Mr. Venkatraman, are you appearing in the one? Okay. You are appearing. Who will be the nodal counsel there?
Mr. Divakar.
Mr. Divakar. So Ms. Manisha Karya and Mr. Divakar will be nodal counsel. Usual orders. And prepare one common compilation duly indexed with written submissions in terms of our last circular. And file it by what date will you file it? Mr. Datta, by what date will you file the compilation?
Your lordship is posting it in August or July?
We'll post it in August, so we'll give you enough time to file the compilation. You can file the compilation including written submissions by the 31st of July and we'll place it in August. Alright, so that seal number 1 is over. That way, we have just one compilation, otherwise it becomes impossible to.
Item 2, the canon matter, we have put a direction now. It has to be, bench has to be constituted, the out of batch of matter there.
So here also can we have one compilation, please?
Yes,
they can do a right? So who will be the nodal counsel?
I will.
Charanya will be the.
V. Chandrasekhar Bharti will be the
panelist. Charanya Lakshmkumar and Mr. V. Chandrasekhar Bharti. And can you prepare the submissions and compilation by 31st of July?
Definitely.
Then we'll keep it in the first week of August and we'll take this up because a lot of matters across India are dependent on this.
Pending. Thousands. Yes, very much. Because this matter, canon matter was passed by 3 judges.
Right.
Therefore, it has to be.
It has to be 3 judges. It will be before this regular bench. Yes, it will be before me and my 2 colleagues. So we are seized of the matter.
As it pleases.
But item 3 is the Google button.
I appear for Google. Your lordship recalls your lordship.
What we'll have to do is, are the compilations ready in Google?
Everything is done. Give dates in September.
Today we started only because we have the NEET matter and literally lakhs of people all over the country are waiting for the outcome of this matter.
No, in September, give dates in September.
Probably in the first week of September so that we can get
a little later, I have the Indus Valley dispute before the neutral expert in September.
Second week of September marathon.
After 15th, after 15th any day.
Submissions have not been received, the courtmaster says, so you'll have to email them.
That will make sure are sorted out.
Alright, why don't you give us on the side of Mr. Salve one nodal counsel?
Yes.
We have filed it. We filed it on the 3rd of October. We'll file it again. We'll send an email again. It's been filed.
Alright, who's the nodal counsel on your side?
Mr. Chandelier is the nodal counsel.
Mr. Chandelier. And what about Mr. Venkatraman, your side?
I've already said in the
They've already appointed nodal counsel. Alright, then make sure that is filed by the 31st of July. Alright.
Yes.
Gaming matter.
This again, the gaming matter.
Are these absolutely ready for the...
Union Marots has filed its counter. Lordships are directed to be filed appointed nodal counsel that has not been
We can do it on a week. We set down 31st of July for completing the filing of the compilation.
Maybe 15th August may be better, Malik, but I'll leave it.
Anti-profiting batch we can exclude, but amongst gaming, no segregation, my lord. Everything has to be heard here.
Agreed. My friend is right.
One second. 15th August may be better.
This exercise has been done in the registry.
Yes.
The gaming matters we've got separately listed and the anti-profiteering matters are separately.
Correct.
So they have to be segregated. Now, what we will do is that the learned council can. This is being done by Charanya.
The list is made. Charanya
Have you looked at it?
Just check it up now. Just let me know.
All right. Ms. Charanya Lakshmakumaran, learned council appearing on behalf of the petitioners, some of the petitioners, has prepared a tabulated statement segregating into single inverted commas, gaming into inverted commas, matters from into single inverted commas, anti-profiteering matters. Full stop. The statement is reproduced below. Copy कर लीजिए. Mr. N. Venkataraman, learned ASG, states that he will have this duly verified within the course of within a week, and intimate the registry in regard to whether he agrees on whether the statement reflects the correctness of the statement. Full stop. This may be communicated to the court master no later than by date on the email ID. The compilations are ready.
The counter was received by us in the writ petitions on Monday evening. So we need some time to file the
It has to be filed. That may be filed on or before 31 July 2024.
Lordship, some of the transferred matters, the councils indicated that they would also like to make written submissions when we checked with them. So they were waiting for direction.
All right. If any further written submissions are to be filed, including the transferred cases, they may be filed with the nodal council to the common compilation. So the written submission shall not exceed 5 pages each. Because
would your lordship set it down on 31st for directions?
Absolutely.
Would your lordship have it on 31st for directions, Manoj?
We'll have it on the 31st of July for directions. Directions on the 31st, which is a Wednesday.
Lordship,
please. Taken first.
All right.
Directions.
Why not just segregated them?
They are segregating gaming and the
anti-profiteering.
There's no difficulty in segregating gaming and anti-profiting. Now, any segregation within gaming is not acceptable.
No.
So we are not asking for it.
No, somebody last time said game of skill should be segregated.
Just to let you know, now you're giving them ideas.
Yes, correct.
No games.
All right. Now, so that covers 4, 19 and 20.
Anti-profiteering date.
So 31st of July, we'll keep it for directions.
Yes.
Just to ensure that everything is complete, then we list it immediately and here.
Great.
Obliged.
Matter, because this is for the gaming matter, now the counter, etc. we have prepared. For anti-profiteering matters, there are no directions in terms of
the circular. So for the anti-profiteering matter, we'll issue similar procedural directions, same nodal council.
Can be done.
Same nodal council, same. And by 31st July, that process must be completed.
You can do
that.
Publish it.
That is neat. Mr. Ide, we'll now stand back the income tax matters. We are not adjourning it for the day, but in view of the importance of the NEET matters, we'll take up the NEET matters, because all the other learned council may step aside and you can have a little time out, but we'll take up the income tax matter because we're not taking up any other heavy matter until we take up that. So NEET only because of the social ramification, we thought we'll give priority to the NEET matter. All right, now
they're all mixed up. 5, 7, 9, and all that.
Now, who's going to open the arguments in the NEET matters for the petitioners?
Manoj, my item 5 is slightly on a different footing. I am showing not merely the leakage of the examinations, but I am showing the...
Because mine is the first matter wherein the...
Mr. Dwivedi, where are you appearing in this matter? Which is pension matter. I think you are safe today because, after this, we are going to take up the parted tax matter, which will take the rest of the day.
So, but the judge's pension matter is again important, and we will take it up probably next week. We'll list it and take it up. Just a little adjustment of the board, that's all.
So far as item 7, if I can, the writ petition under Article 226 of this candidate is pending before Honorable High Court of Delhi. He has filed writ petition under 32 before this Honorable Court also, saying that I will withdraw that. This is the third time consecutively where he is alleging that my OMR has been replaced, which is factually.
All right. That we'll see what to do there, because that's not about the systemic issue, but about his own OMR sheet. There we may be who's appearing. Which one is that? Serial number?
Item 5. 514.
So 5, why don't you do this? Go to the High Court. Whether your OMR sheet has been replaced or not, there is not a systemic issue.
High Court has already passed the judgments. High Court has refused to examine this issue. My lord, I had delegated.
So why have you filed a writ petition? You have to file an SLP then.
No, my lord, in 2020 I went before Honorable High Court on the directions of this Honorable Court.
Now High Court is held against you.
In 2021.
21 hoga, 20 hoga, 19 hoga, 23 hoga.
Lord, since that.
But now tell us, what remedy do you have against that judgment of the High Court?
Against that, even if I come in SLP, my lord cannot grant me an admission. My lord, I am saying I reappear in the examination in the.
Fair enough. We'll entertain your writ.
Yes.
On one condition, that now then we will treat the order of the High Court as attained finality.
Yes.
So we will then hear your writ on the footing that the order of the High Court has attained finality. So you are taking a chance.
My lord, High Court refuses to examine the issues. That's the final.
We'll see. We'll see when the matter is called in.
My lord, may I?
Mr. Ammutu, we have seized of the matter. We know how important it is. It's about our own retired judges. But we have the NEET matter today, so we'll give priority to the NEET matter today. We just indicated to Mr. Dwivedi, we'll try and accommodate it sometime next week, so we'll take it up immediately. We'll just give me a little time, so I'll just in the evening discuss the board position with the court master, and then we'll take it because we have to take it up.
My lord, I'm here for item number 6. I have the same prayer that my OMR sheet was replaced and the.
All right, let the matter open up now. If everybody just keeps on giving your individual. Who's going to open the hearing?
Yes, mine is the first matter, my lord, where they have filed their responses.
So we'll hear Mr. Huda first.
Yes, my lord, I'll supplement whatever he is.
All right, and then we'll hear the solicitor.
Your lordship had an occasion to go through the second status report.
Yes, we've seen the second
now that is something is crystal.
We've seen the second status.
Yesterday it was.
Yes, I saw it in the morning today. After the day. Both my learned brothers have seen the second status report.
May please, lordship. No, that's good. Thanks. This is yours? Just one suggestion. Okay. All my will get ready first play.
My lord, in item 5, may I please request that the first prayer is, my lord, that.
You're not arguing it. You have somebody before you who is to argue his matter.
They are in item 7 and item 5, I am making a request.
But which is the lead prayer? Which is the lead matter? Are you prepared to argue the whole matter on the leak, etc.?
No, I'm on the, not on the legal aspect, my lord.
Then why are you interrupting the flow of the proceedings, Allow somebody who's arguing the main matter to take charge, right? We'll hear you at the end, no problem.
Because so it's not replied.
May please, lordship. Lord, 2-3 things at the outset, Lord. As per my Lord's direction, CBI was supposed to file their status report. Filing, we understood it will be filed and it will be supplied to us. And that was the direction of the point. Yes.
The only problem is this. Pardon? The only problem is this today. I mean, I am all for transparency. In fact, this is not a sealed cover procedure. Let me be very clear. But today an investigation is going on.
Correct. I might follow that.
If what CBI has told us in the course of the investigation is revealed, probably the investigation will get scuttled because people will become wise on what are the leads which have emerged in the course of the investigation. So that's the only thing.
I bow down straight away. My only, you see, the intervention in between will cause a problem.
And so what we would like you to do, Mr. Huda, is
Please.
you have to, redaction is not possible in these kind. If it's redacted, then it will have nothing of it will have nothing of substance. You will have to show us, prima facie, on the basis of your submissions, that the leak is so systemic and has affected the entire examination process across the country that we must cancel the examination and direct a fresh examination to be held.
Yes.
That is the area where we want to hear you. And then we hear the learned solicitor in response to that.
I will assess this honorable court.
Just 1 second. The second, we have some ideas also on what we are going to pose to the solicitor thereafter.
Please, Lord.
We would like you to assist us on assuming, if we accept your wider submission that you must have a fresh NEET examination, then that's what you exactly want. Suppose in the alternative, after hearing you both, we are not with you, then we would like you to also assist the court on which are the further lines of investigation, what are the lines of investigation which must be carried out, in the sense that which are the specific issues which must be investigated. So we would like your assistance on both, the other than alternate argument.
Yes, but that alternative argument has also come in my supplementary note which I circulated yesterday.
Okay,
in the same matter, I have suggested that this is the line of investigation should be conducted to unearth this entire controversy.
All right, then we'll look at that. Later on, we'll read it with you.
At the outset, Lord, I was flagging my handicap in I'm assisting. I'm not saying that. But the handicap I have in assisting this honorable court in this leak matter, one, they have not declared the entire result. They have declared the result of 100 people. And my assistance is information gathered from here and there. UPSC, Lord, in IAS exam, they declared the result of entire people. At least they should have declared the result of this 1 lakh people who get admission. First 50,000 in the medical colleges.
Just one second.
The two handicaps, Lord, may kindly notice, I will have in the course of my assistance to this honorable court.
First 50,000. How many seats in the government medical colleges?
56,000. And Lord, everybody clamor for these first 56,000. Even the people below 56,000 may be willing to go for a re-examination.
And how many in the private medical colleges?
52,000. 56 and 52. That is 1,08,000. Now, Lord, if re-exam happens, literally it is, if all of them do not want re-examination, the total number is 1,08,000 people, not 23 lakh people. The remaining 22 lakh people
have not got admission at all.
Have not got admission. So they are willing.
Except for the fact that if some people have wrongly got into the 1,08,000 category,
that's right.
Then somebody below the 1,08,000 can legitimately get into that 1,08,000.
That's right. So, but in fact, the balance is this 1 lakh. If all of them 1 lakh don't want re-examination, this 1 lakh on one side and 22 lakh on the other side who would like to take a chance in view of the this examination is marred by controversy. All 22 lakh would like to have a second chance.
That argument, yes, Mr. Huda, there's a problem. Forget the question of leak in this matter. Merely because, say, out of 22 lakh, 1,08,000 only have got admission or would get admission, and therefore you are left with, say, about 22 lakh students who would want to take a chance. We cannot order an re-examination merely because they want to take a chance.
But I just wanted
re-examination has to be on a concrete footing, that the sanctity of the entire examination has been broken.
Bow down. I just wanted to dispel an impression that the stake in the re-examination is of lakhs of people. No, the stake is of 1,08,000 people. I will have to set up, demonstrate conclusively that we cannot segregate tainted from the untainted. In Tanvi Sabharwal case and the judgment authored by Malone, clearly says in Tanvi Sabharwal's case, the finding was we have identified 44 candidates out of 6 lakhs. The remaining we are not able to identify. So we cannot permit even 10 people.
So would I think, you need not labor that point because you're absolutely right on that.
I'm so great.
That if you can, as a conceptually, that if you can establish that it is not possible to segregate the tainted from the untainted, then the whole examination has to go. Because those basic, you can of course show those authorities briefly to us at a certain point. But when we have looked at the facts, but before we go into the authorities, we want you to address the core of the facts before us.
I will try to first summarize my case and then elaborate. So that has an idea what I am saying.
So you can summarize now. My brother Justice Padiwala would like to know, out of 1,08,000, totally how many petitioners are before the court?
Good. But it is NTA can say, but
38 petitions. Yes. Now you're for NTA, no? Okay.
38.
The transfer petitions made by the NTA, my lord.
So 38 petitions includes the 6 transfer petitions or transfer
petitions before this one would include the 6 transfer petitions made by the NTA. So 32 petitioners, 32 petitions.
Our question is little.
I represent 10. And from
how many are asking for?
Supported by 43.
I do not know how many, at least 100, the candidates called us individually, but who have not petitioned.
I think they have a figure. 108. 108. Mr. Kaushik, if you can just ask somebody, any of your team from the NTA, to just do this physical exercise of telling us even at lunch or after lunch, how many total students are involved in the matters before not involved, but how many students have moved the court in this batch of cases?
I have not seen with utmost respect, my lords, that may
Approximately 108 are seeking reconduct of the examination.
The council,
50.
108 who are seeking re-exam are amongst 1,08,000.
No.
Yes. Yes.
No, they will be outside 1,08,000.
We are outside 1,08,000.
They can't be.
Because 1,08,000 would get, they have succeeded.
They are not seek re-examination at all.
I represent.
So all those who have not been able to clear.
Some people within 1,08,000 are also before your lordships because they say
they will not get into government medical.
They will not get into it.
In my pixel,
seeking re-examination.
in my pixel 700. In my lab pixel, my lab, there are 5 candidates. One of them.
Now in charge, unless we ask a question to some other council, the others may not interrupt because otherwise, our line of thinking is also affected. And he's deflected also. He has his thought process in some matter, yes.
Out of total.
But they are not in mission.
I'm on your side, man.
Also, Brother Manan Mishra had a point. What is the minimum mark which has been received by the petitioners before the court? We just want, you need not give us an offhand answer, just do it at lunch and tell us.
My lord, can I have one thing, my lord? In 5 petitioners in my petition, my lord. One is having 700. Another is having 600.
How will we be able to, just wait for a minute. Let's have the conceptual basis of the matter. We can't go in individual facts like this. Let's have the concept very clear before us, and then we can see where the balance lies. Yes, Mr. Wood. We'll hear you. We're not going to run away. We are here to hear you and do justice to the matter.
Qualifying marks are 164.
Done this exercise, there are 131 students who are not falling within 1,08,000, and they are paying for retest.
131 students.
130. And petitioners, and there are 254 who are falling within 1,08,000. They are opposing them. Not that statistics can assist your lordship either way, but factually this is the position.
So 131 students beyond 108,000 who want a retest, and
254, they are in the form of IAs, not for implement.
Who are opposing?
For opposing the retest. They are fall within 108,000.
The figures may not always be right, my lords, because I represent somebody who falls within.
Yes, that's good.
And whose rank is about 2009. But, so, my lords, we'll work out the figures in common with Mr. Kodak.
Now tell us also what is the cutoff rank for the 56,000 and for the 108,000.
May just one clarification, conceptually. Anybody who is above the 50th percentile qualifies, in the sense that if somebody above them also does not go into medicine, goes into IIT, for instance, there will be a figure. So passing is 164. Passing is 164, but admission is a dynamic process, may stop at 1 lakh, may stop at 1,50,000, and depending on the particular quota or reservation or whatever is available. 164 is the cutoff mark. 164 means that you are above the 50th percentile. So about half the people have a qualification to be allotted a seat, but not everybody will be allotted a seat. So it's a dynamic process. There is 108,000 seats available. Some of them may not opt for medicine, some may go into IIT, this, that, and the other. The figure will come down. And also depending on whether you have a reserve category or something. So it is not, so it is dynamic, but roughly say, I think the last figures will stop at 2.5 lakhs, rank-wise. That's
let's hear Mr. Hudana. Yes, Mr. Hudana.
Wait, please, Lords. So, my lord, I'm starting.
Can you summarize your case, you said?
Yes, I'll just summarize. But give me a space, please. Look, I'm starting with a handicap. I do not have the result. Because of that, I cannot have the data analytics, which the state has placed, NTA has placed on record, giving the bell curve. And one of the director of IIT Madras is a member of the governing body of NTA. They have run the data analytics process, taking the entire number of 23,33,000 candidates who sat in the examination. If data analytics is to be run to 23,33,000 people, at what stage 10,000 or 20,000 people have sneaked into it? This data analytics running into half a page, which every dot means thousands of people. You cannot detect any abnormality when you draw a bell curve, which is based on 23,33,000. The correct procedure, if at all they were doing it, the correct procedure was to apply this process to 108,000 people. The first 1 lakh people in 2021, 22, 23 and 24. Probably the curve would have been able to catch 1,000, 2,000 people going up and down. Now even 1% is into thousands of candidates. This Honorable Court has not tolerated, even if it comes to a conclusion that 1,000 people have entered into the system of this 1 lakh, which we are not able to detect. This examination cannot be sustained.
one aspect about what IIT Madras has done. Now, what about how do you develop? Now, you can develop the basic case that you have.
I'm demonstrating that IIT Madras can't be relied upon.
Because they've taken the entire body of 21.33 lakhs.
That's it.
And according to you, that data analytics should have been done on the restricted figure of 1,08,000 and compare that with 2021, 22 and 20.
So great. And Willard, the governing body member is the of NTA is the director IIT Madras. There is a conflict of interest, Willard.
No, but therefore, you take it, I mean, what is at the highest, what does that lead to? Your argument is that the data analytics has been done by NTA itself.
Correct. That's
it can't be higher than that.
And apply.
That's because the director of IIT Madras is also on the governing body of NTA.
That's right. Actually, he's not.
He's not, they say.
He's present in the court in my request. He says he is not on the board of directors of NTA.
Oh, I see.
He was an outsider who's not expertise.
But anybody from IIT Madras who is on the governing body of NTA?
He was. Somebody else was.
Was means in the past.
In past.
Today IIT Madras has nobody from IIT Madras in NTA.
When was that password when he exited?
But the director who has prepared this report.
Mr. Solicitor, just sit for a second and ask them what the position is so that you can have a seat.
Where you a member of this is not the way it is done. Please don't do this.
I have not attended any board, not your
member. He is not a member. Any other person who is a member.
I'm not person. What's the previous guy?
When?
I stay down district.
डेटा एनालिसिस की बात चल रही है कि मद्रास आईआईटी ने किया था, तो यहाँ पर डिस्कशन जो चल रहा है उसमें कह रहे हैं कि भाई वो तो गवर्नमेंट की बॉडी है, वहाँ के जो डिसीजन लेने वाले वो तो गवर्नमेंट के हैं, एनटीए के हैं, सरकार की ओर से हैं। उस पर डिस्कशन चल रहा है कि वो एनालिसिस किया गया था, वो कैसे किया गया था, उसको किस हिसाब से माना जा रहा है, डिस्कशन चल रहा है उसमें। अभी म्यूट कर रखा है, आपस में डिस्कशन कर रहे हैं जो सुप्रीम कोर्ट के चीफ जस्टिस और उनकी पीठ है मिलकर के। और अभी जो पिटिशनर्स है उन्होंने कहा है कि जो सीट को लेकर के अभी जो बोला है उसमें कहा है कि 56,000 और 52,000 टोटल 1,08,000 सीट जो है ये अवेलेबल है। और अभी जो एक पिटिशन है उन्होंने ये भी करे थे 164 जो पास मार्क 58% का लेकर के करें, तो स्टूडेंट का मतलब किस तरह से एडमिशन होना चाहिए, क्या होना चाहिए, अभी हमें इंतज़ार करना है, इनको सुनना है, ध्यान से सुनना है। इसलिए मैं साइलेंट हो चुप हूँ, एकदम सुन रहा हूँ, आप भी सुन लीजिए बस ध्यान से। जब तक वापस स्टार्ट नहीं होता है तब तक मैं बोल रहा हूँ, जैसे ही वापस से इनकी वॉइस स्टार्ट हो जाएगी मैं वापस साइलेंट हो जाऊँगा, क्योंकि बहुत बड़ा डिसीजन है। हम आज खुद बोलने वाले नहीं हैं, सुनने वाले हैं। जब डिसीजन आ जाता है उसके बाद में हम बातचीत करेंगे, डिस्कशन करेंगे। अभी आपस में बातचीत कर रहे हैं, म्यूट किया है इन्होंने और आपस में डिस्कशन कर रहे हैं। पिटिशनर्स जो है वो भी आपको सारे के सारे दिखाई दे रहे हैं यहाँ पर, और माननीय सुप्रीम कोर्ट के चीफ जस्टिस और उनकी जो पीठ है वो भी आपको दिखाई दे रही है। जैसा कि आपको पता है कि ये जो पूरा का पूरा मामला है उसमें कौन कौन इसके अंदर है। हमारे मुख्य न्यायाधीश धनंजय यशवंत चंद्रचूड़ जी, न्यायमूर्ति JB पारदीवाला जी और न्यायमूर्ति मनोज मिश्रा जी शामिल हैं।
Subject to further verification, but the IIT, whichever IIT organizes JEE examination, IIT JEE for selection in, the chairman of that examination committee is ex officio member in this NT. But the office for the director who has prepared this report is not the member. But some Mr. Gopal.
Now,
IIT JEE for 2024 was held by IIT Madras or who else?
IIT Madras. He is the chairman of that IIT JEE examination committee. But he deputed somebody to attend meetings of NTA.
Oh, I see.
He ex officio is there to use his expertise.
So I'll just take it down. IIT JEE for 2024
was conducted by IIT Madras.
Yes.
And the chairman of IIT who conducts IIT JEE, ex officio is a member of NTA.
And what role does NTA have in regard to the IIT JEE?
Nothing.
There's no.
He is.
I just asked the director.
NTA conducts JEE.
So the actual NTA, the actual IIT JEE mains are conducted by NTA.
Yes.
Oh, I see. So IIT Madras would only set the papers or what happens?
No, they would conduct the examination. Advanced they conduct, JEE mains is conducted by NTA.
So mains is conducted by
NTA.
By NTA. That's like the preliminary exam. The mains.
Advanced.
Advance is like advance is only
final.
This is only for IIT. Whosoever is intended to get admission in IIT, they opt for the advanced. Otherwise, all other
they are only the admissions are on the basis of IIT JEE main.
The mains.
And IIT JEE advanced. NTA doesn't conduct that. So IIT JEE advanced is conducted by whom?
NTA.
No.
This is conducted by IITs.
IITs or one IIT?
One IIT. It is conducted by IITs. One become the organizing IIT. This year it was IIT Madras.
Okay, so like the CLAD.
Yes.
So this year, the IIT JEE Advanced, the organizer was IIT Madras.
Correct.
Okay.
And he has gone into city-wise as well as center-wise analysis.
Now, when you said that the chairperson of IIT JEE is the ex officio member of NTA, of the government, is ex officio a member of the governing body?
The governing body has no correlation with the activities of the conduct of the exam.
So the IIT JEE, the chairperson. So this time, who was the chairperson?
I think this time chairperson. He was the chairperson.
He was the chairperson. He deputed one Mr. Gopal Krishnan to attend the meetings on his behalf.
No, but who was the chairperson? The director of IIT Madras was the chairperson?
For G. Because IIT Madras was the organizing body.
So IIT Madras was the organizing body both for the mains as well as advanced, or only for advanced?
Only advanced. Mains was conducted by NTA, by us.
Entirely. But IIT Madras's director was an ex officio member of the
governing body, which is a kind of
NTA. And is he an ex officio member only for this year or generally?
He would be whichever IIT conducts the exam.
For that year, he becomes a member of the governing body. All right, got it.
But I must tell your lordships, my lord, that what is placed in the report is, my lord, for say a city-wide spread of top 100 rankers.
This time the director IIT Madras would be ex officio a member of the NTA, but he had deputed somebody else on his behalf to attend the meetings.
One Professor Gopal Krishna. And I have city-wise and center-wise.
That I'm explaining.
But deputed professor or doctor?
Gopal Krishna. Professor Gopal Krishna.
अभी हाल ही में हमारे साथ जुड़े हैं, उनको हम बताते हैं कि नीट मामले पर सुप्रीम कोर्ट में सुनवाई चल रही है और लाइव आपको हम दिखा रहे हैं। और दूसरी बात, अभी जो माननीय जो सुप्रीम कोर्ट है उनमें जो चीफ जस्टिस है उन्होंने पूछा है कि भाई जिसने एनालिसिस किया है, डेटा एनालिसिस किया है आईआईटी मद्रास ने, तो वो क्या गवर्नमेंट इसके आपके अंदर जो नीट से रिलेटेड उसका कोई कनेक्शन है क्या, या क्या करवाते हैं, किसके अंडर में आती है। तो अभी डिस्कशन ये चल रहा है कि वो जो जेई जो है उसका एग्ज़ाम करवाती है, और वो जो एग्ज़ाम जेई के लिए वो मतलब बॉडी है उसके लिए, बट एनटीए उसी एग्ज़ाम को भी कौन कराता है, एनटीए ही करवाता है। इसको लेकर के डिस्कशन चल रहा है अभी। जैसा कि आपको विदित है कि आज नीट एग्ज़ाम को लेकर के सुनवाई चल रही है और सुप्रीम कोर्ट का लाइव यहाँ पर आप देख रहे हैं। और
if my learned friend is going on the question of bias, that may not help here. I have sat with him, my lord, I have examined everything which he has done. Yeah, I can show it to your lordships, and lord, it is city-wise, center-wise, and at the national level.
Yes, lord,
just so that there is no.
That can indicate when your turn comes. Notice. Or right now,
without showing the document. Additional affidavit dated 10th of July filed on behalf of respondent number 2, Lord.
NTA dated 10th of July?
Correct, Lord. That's right. Lord, this is respondent number 2. Annexure 8, page 12.
Page 954. I need to It's analysis of the 17 candidates or no?
Lord, this annexure is data analytics of NEET UG 2024, annexure A.
Lord, it may be part of the petition filed by Shivangi Mishra.
Shivangi Mishra.
That was the first.
Yes, it is in Shivangi Mishra's case, my lord, because they didn't file it in my case.
Yes.
Yeah, we got it.
But copies are served or not?
Yes,
that is
copies are
report from IIT Madras, pages 12 to 18. Let's see that.
Yes. Now, you see, at page 12 is there's an executive summary given on page 1, and then the charts. Executive summary indicates they have gone all the way to explain. If I can read it, the executive summary.
Yes.
Marks distribution follows the bell-shaped curve which is witnessed in any large-scale examination.
Just 1 second. Then I should.
Yeah. Executive summary, short summary. Marks distribution follows bell-shaped curve that is witnessed in any large-scale examination, indicating no abnormality. City-wise and center-wise analysis done for 2 years, 23-24, to find out if there are any abnormal indication. Analysis is carried out for the top 1.4 lakh ranks, given that the total number of seats across the country is around 1.1 lakh. This analysis is granular enough to indicate any abnormality had a large number of students gotten into high rank top 5% due to malpractice, or if students from a particular exam center or city were benefited. The analysis show that there is neither any indication of mass malpractice nor a localized set of candidates being benefited leading to abnormal scores. I would say this is beyond their brief, what they are stating here. D, there is an overall increase in the marks obtained by students Next. E part, there is an overall increase in the marks obtained by students, specifically in the range of 550 to 720. This increase is seen across the cities and centers. This is attributed to 25% reduction in syllabus. That's not there for them to say. In addition, the candidates obtaining such high marks are spread across multiple cities and multiple centers, indicating very less likelihood of malpractice. But if I can take just one moment here. NTA, the Government of India, in their reply is talking that they are attributing two reasons for this exponential inflation in the marks. Two reasons are there is 22 to 25% syllabus reduction and hence the inflation. Two, increase in candidates. Nowhere there is a whisper that there was increase in the syllabus that we have placed on record. If not more, at least corresponding. So, if I can say so, the reply is not giving a full disclosure for oblique reasons. If they are talking about deleting the syllabus, they should simultaneously talk about increase also. At least they should disclose it. I will show the increase part of the syllabus. I will come to it. So there is an increase and decrease both. But this IIT Madras is talking about 25% reduction. Probably they are not given the papers that there is an increase also. And why IIT Madras will not?
Let's look at the data.
Yes. Now kindly see the first table. This table blood is for 23 lakh people. They say it is a bell shape. And any large examination will have a similar kind of a shape. And hence, there is no red flags. Now, starting from extreme right, where 720, now it is going up to the marks. Now, at every stop, there are thousands and thousands of people. This one line, which encapsulates about 24 lakh people, cannot give them any abnormality if 10,000 have gotten into this system through a back door and there is an inflation. Inflation is admitted, leak is admitted. They are trying to justify it that it should be the same curve, and it is the same curve. So this is no indication that there is no abnormal. That is my respectful submission. Because of the data is too large, which can't be caught. Granular variations can't be seen with this large data. Now, we kindly see the next table. They say the city-wise top ranker analysis. plot of the marks obtained versus number of candidates for all the candidates who took the examination. Similar analysis was carried out by NTA for every city, and the results followed the same distribution. This was verified by IIT Madras team. This further strengthens our view that there was no major abnormality. There can be abnormality, but there is no major abnormality which can be caught by this system if this Python software is run through 24 lakh students' data. Now, we can see center-wise top ranker analysis, which they say that there are city-wise. There are 571 cities. They say first top 100 are evenly spread, and then the data they give is only with regard to 17 students. Bangalore, Karnataka 5, Lucknow, Uttar Pradesh 4, Kota, Rajasthan 3, Tamil Nadu 3, Patna, Bihar 2, total is 17. Why are they shying away? If they have run it for top 100, they should give for top 100. That will include Hardayal School, Bahadurgarh, which had 8 candidates from the same center. Now, they are leaving us in darkness because they have the data, we do not have a data. So whatever they are saying, we are trying to analyze and find that is it correct or not. Now, the same story runs through all their tables. Can you see the next table?
Maybe. But I can give, there is no difficulty. Just to
all right. I'll read the narration also.
Only a minute, just to give the context. This chart shows that out of students who got first top 100, and we are not counting those 1563. Please don't count them because they become a separate class.
My only limited objective is why send only for 17 people? Why don't they give a data for 100? Top 100.
I'm answering that. Please allow me to. If you listen to it. In Bengaluru, just to show the difference, in 23 there was 1, here it is 5. Maximum in India, the city which got 100 the ranker is 5 in Bengaluru, Lucknow 4, Kota 3, Namakkal 3, Patna 2. Rest are 10101.
But do you have the breakup of the top 100 ranks?
Yes.
Top 100 ranks, if you can give us what cities do they come from? Because we have now got the data for the 17, 5 and 4, 9 and 3, 12 and 15 to 17.
Rest would be 1010.
You can just give us in a chart, you can set it out and give it to us and give it to the others also. That if you take the top 100, which are the cities from which they are?
Our counter affidavit at page 118, we have shared the 100 side also, and we have placed it.
Just give it to us separately right now.
Yes.
You have it right now, just give it to us.
Separately, it is annexed to our counter affidavit.
Where is it? It just page.
Your counter.
Page number 1 page.
Counter of NTA.
Item 7.
Vanshika, yes, sir. One minute. Yes. 100 कहाँ से बने?
So, with 91.
They are spread to 91 places, but these 5 are top. Bangalore has maximum students, 5 who are in the first 100. Rest would be 10, 10, 10, etc.
We said 950, Affidavit on behalf of NTA?
Yes, my lord, 118, annexure R19.
A19.
R19. PDF page 121. Replies. PDF 120.
Hey, 121 is some Wakalatnama.
Annexure.
Analysis of top 100 candidates.
Counter affidavit on behalf of NTA?
Additional affidavit of NTA.
Additional affidavit of NTA.
The petition number would be Writ petition 335 of 2000.
Correct, correct. So one Vinod Kumar Sahu is the deponent?
Yes.
Right. Got it. There we have got the annexure A1 is a performance analysis of 17 candidates of Patna, Bihar.
Yes.
A2 is copy of screenshots of messages.
Correct. Say.
Now, which is the chart that you're referring to?
118. In the entire country, the analysis of top 100 candidates.
Where is that actually?
That exactly, my lord, annexure
118, my lord, annexure 19, R19.
118. पेज नंबर तो 118 होगा.
Additional. It's continuous page PDF 2070. 1070.
There is no top ranker.
इसको नहीं कहीं कर सकते.
But this is the addition.
माननीय जस्टिस जी द्वारा पूछा जा रहा है कि टॉप रैंकर कौन कौन से कहाँ से हैं. इसके जवाब में पेज नंबर कुछ बता रहे हैं यहाँ पे.
So here, center-wise toppers for all 100.
Right. So first is Guntur.
That's it.
But can your lordships come to 121?
Yeah, we got it.
We have 121.
Yes.
Please see Lucknow.
See which one?
Lucknow, my lord. Uttar Pradesh, Lucknow, my lord. Left hand side, first column, Uttar Pradesh, Lucknow. 2, 1, 1. Your lordship gets, my lord? Lucknow, Uttar Pradesh is the state, Lucknow is the city, and SDSN Mahavidyalaya is the center. From that center, out of 100, 2 candidates fall into our 100, first 100. Then in Lucknow, Loyola International, 1 student, and Uttar Pradesh, Lucknow Central Academy, 1 student. Total up to 4. And therefore, in the report of the IIT Madras, they mentioned Lucknow as 4.
Lord, may at the same page, Lord, may kindly see at page 120, there are 9 people, 8 people from Jaipur, which they have not captured in the table. Kindly see the Jaipur bullet, page 120. Yes. Jaipur alone has bullet 1, 2, 3, 4, 5, 6, 7, 9 people.
Sir.
They have captured 2. They have not captured 9.
कहाँ से?
You're right. 1, 2, 3,
9.
4,
It is
5,
9.
6, 7, 8, 9 probably.
No, 8 seconds.
7 people from Bihar, my lord, in this.
Uttar Pradesh we get 2 and 1 3 and 1 4.
Yes.
That 3 from Lucknow, 2 from Noida. Lucknow 4. Lucknow 4, no?
But the purpose is to show that they are spread over. That in Lucknow, there are only 4 out of total 23 lakhs who appear. But just to show that if there would have been any stage of practice, in one center there would be a spike. That's the intention.
Bihar there are 7, right?
Yes.
Bihar there are 7. Yes, my lord.
56. Six.
State-wise, Bihar, there are 7.
Yes,
Right?
yes, brother.
Then Haryana, how many?
Pradesh 7.
Gujarat, there are 1, 2, 3, 4, 5, 6.
Haryana 3. 4. Haryana 4, Millard. And Lord, may kindly notice Haryana 4 is in a situation, if I can be given a moment here.
Yes.
There was one Hardyal school in Bahadurgarh where 8 people were from the same center. And the story of that center is, Lord, the paper distributed in that center, 500 odd student, was taken from Canara Bank. Paper was
a different issue.
That's a different issue, but I'm showing it has a relevance.
But Haryana, there are 4. There are 4 in the top 100.
Lord, there were 6 people in the top, which are not, they are not there now. Because what happened, Milord, in Bahadurgarh, Milord, that's one other glaring thing I just want to state here. NTA never disclosed it. That in Hardyal school, Judgement, the question paper taken from Canara Bank was distributed. That paper was taken. There was absolutely no delay in distribution of paper. The principal of the school is on record on YouTube. Even here it can be shown. She says that we collected paper from SBI as well as Canara. Ultimately, the instructions came that you distribute paper from. Allow me to state it.
It's a different issue. We will not
different issue that which you have never disclosed on affidavit till now. And I will demonstrate in court. That's a very clinching issue which they are getting agitated on that. Paper taken from SBI as well as Canara both. The paper was distributed, which is taken from Canara Bank. The entire country was giving the paper taken from SBI, but Hardyal School, Bahadurgarh, paper was given, distributed, and ultimately full time was given and paper was taken on the basis of Canara Bank. Answer that we should call it from. Now, what happened is, just if I can complete it, what happens is the principal says that after about 40 minutes I conveyed it that we were told Canara Bank and now these students are attempting Canara Bank question paper. And the instructions to her was that all right, if it's already 40 minutes, so let them do Canara Bank. They did Canara Bank. Ultimately, what they did not disclose it to anyone, but they gave grace marks to everyone in that school. And because of those extra marks, 6 people got 720 out of 720. 2 students from the same center got 718 and 719. Thereafter, this was a grace marks given.
Of course, thereafter a fresh examination was held.
No, Lord, Lord, that is impinging upon the entire system they have. Now, initially, they arbitrarily gave grace marks for which they were not entitled to at all. Now, this is how they have given grace marks across the country. There was absolutely no justification because they have not come clean on that. Here, they should have said, in Bahadurgarh, a different paper was given. That is why we are holding a re-exam. Fine. First, they said that there was a delay in distribution of paper. There was a loss of time and hence grace marks. When they were caught in this court, then they appeared before the Honorable Other Coordinate Bench and said, now we are having a re-examination, so please do not go into how we gave the grace marks to this 1561 people. 1563. So the question that how they gave grace marks to 1563 people on account of loss of time has not been examined by this Honorable Court. They in their reply, they say that the issue stand resolved because we have had a re-exam. My question is, Lord, that how in the first instance they identified 1563 like the center in Bahadurgarh, and to hush up the matter they say we have a re-exam. Now, Lord, if it was on account of
loss of time. They should have given opportunity to everybody in the country. That wherever there is a...
Mr. Huda, that was attained finality. Our board dismissed that, our court has upheld the re-examination. Initially they decided to give grace marks to everybody. That was, when that was done, there were representations, they said. They told us last time that there were representations. Thereafter they decided to revoke that because a fresh committee was appointed and they decided to have a re-examination. Is that correct?
My most respectful submission,
I may have to interrupt here only for a moment, my lords.
Later.
My respectful submission is not this. In the first instance, they indulged into pick and choose for identifying 1563. One classic example is of Bahadurgarh. Then nobody knows how they picked up 1563. And re-examination, the people who were not entitled to get this chance again, got the chance again. And out of this number, out of the total, out of 1563.
Out of 1563, how many make it into the 1,08,000?
Yes, that's an interesting question. They have not disclosed. But out of 1563.
Tell us. That's the proof of the pudding isn't that.
Yes, sir.
Out of the 1563 who got the retest, how many actually have made it?
Which included 8 top ranker from one center.
We'll find an answer to that.
Now,
see, I've done now in the top 100. These cities gave reputations high. Seems like not the top.
जैसा कि आप देख पा रहे हैं, पिटिशनर का सवाल है कि 1563 जो स्टूडेंट है उनका सिलेक्शन किया गया था, उनको किस आधार पे किया गया था, जिसके अंदर 8 टॉप रैंकर्स भी इंक्लूड है। ये एनटीए ने कोई क्लोज नहीं किया, डिस्क्लोज नहीं किया।
When you are arguing, I've just from that top 100 I've done an analysis. The maximum from the states, you said they had disclosed data only for 5 states, 4 or 5 states. Now Andhra Pradesh got 7 in the top 100. Bihar 7. Gujarat 7. Just check this up. Ask your team to check it up. I've just done it manually. Andhra Pradesh 7, Bihar 7, Gujarat 7, Haryana 4, Delhi 3, Karnataka 6, Kerala 5, Maharashtra 12, Punjab 6, Rajasthan 19, Tamil Nadu 8, UP 6, and West Bengal 5.
That's right.
So it appears that the spread in the top 100 marks is distributed across the country.
Yes. Look,
this covers 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 states and 12 states and 1 UT.
That's right. That's right. On this 1563, I just want to point out one fact. The people who got re-examination opportunity, out of them 773 did not pass the basic marks in the
100 candidates. Our affidavit, my lord, says first 100 candidates was analyzed and it has been reported that they are distributed across 95 centers located in 56 cities within 18 states and UT of the 69, my lord. In Vanshika Yadav.
What have you said? That the first 100?
In this regard, just read, my lord. It is submitted that allegation of the petitioner that number of students scoring high marks are only from certain center is completely unsubstantiated. In this regard, the result of top 100 candidates was analyzed and it has been reported that they are distributed across 95 centers located in 56 cities.
Yes.
Within 18 states or UTs of the country. This diverse distribution highlights the widespread participation and competitive spirit among students from different regions and educational backgrounds.
Mr. Huda, this is not only on the other aspects, but if you look at, as they say, first 100 candidates are distributed in 95 centers in 56 cities and 18 states. Apart from that, as we said, the maximum we have taken in students at least 5 or more per state. 5 or more per state, we find their distribution in 12 states and 1 union territory.
Yes, sir.
With the highest being Maharashtra, which is, Rajasthan 19, followed by Maharashtra 12, followed by Gujarat and Bihar 7, and Karnataka 6.
Yes, good.
For us, my lord,
67 students.
yes, they
Who secured 720 out of 720.
they are also, my lord, reduced now because of the re-examination.
Now tell us, originally 67 students.
Yes, please.
Got
720 out of
720 out of 720.
Yes.
Now, how many of those were in the, I think 17 were in that 1563, no?
Yes. No, no,
44 means.
How much? 44?
Initially,
They are reduced.
7 were there.
But
which
I
got
give-
reduced-
Yes.
got reduced to 61 because of re-exam at Bahadurgarh. And it's 44 we are attributing to the aspect of one question paper in which 2 options were marked correct. As a result hereof, it's 44 candidates got the benefit of extra 4 marks, making it to 720. If those 44 are removed, then toppers in the entire country are only 17.
And so 44 students got the benefit of the grace marks.
Grace mark.
Not grace marks, full marks for when there was an error in the NCERT book contained the wrong answer.
Logic is that.
No, there were 2 correct answers. Yes, that's what.
So anybody who gave either the NCERT answer or the actually correct answer was given graded as correct.
If they are removed,
They were 44.
Yes.
because they will otherwise get minus, because this is a negative marking system.
Because you didn't go by the NCERT, your booklet didn't go by the NCERT answer, but what was truly the correct answer? They said that, look, the earlier edition of the NCERT book had also this answer.
Now,
so you treated both as correct answers,
Yes.
and those are 44 students.
And total, my lord, are otherwise 17, which in a multiple choice question, my lord, framework is possible in that out of.
So now, as it stands, 61 students across India get 720 out of 720 today.
Yes.
Out of which 44 students have got the benefit of that one question where there were two correct answers were treated as the correct, 2 options were treated as correct answers.
So you cannot we have
17 remains. The balance 17 really.
If 44 are
and the real purpose.
100% students.
No expectations.
Now tell us one thing, out of these 61 students who have now got 720 out of 720, or let me put it this way, in the top 100, are there any cases where students have changed their centers? In the entire exam, Mr. Kaushik, how many students changed their centers in the entire exam? 23 lakhs. We'll go step by step. In the 23 lakh, total number of students who appeared were 23.33 lakhs. How many students have changed their centers out of the 23.33 lakhs?
Yes, the center allotment is only on 2 aspects, only two factors. One is permanent city and the current city residence. We do not give any specific option with regard to the change of center. Let the correction window is opened up. In that, the field may be changed by the candidates, which will not come to our knowledge.
So that will be permanent or the current city?
Yes, it's only two options.
So once you are registered, you can't change your center.
Next, what they do is, in the name of corrections, some students change the center also, correcting the parameters or the fields of the application form. We give correction window for some time. During that process, only the possibility of change of center.
But you will never know it.
No minutes. That also has to be on the basis of minutes the address.
But you don't have the fields which are originally filled in by the student and the corrected fields.
So far, as of now, the system doesn't catch that.
So we don't know how many students actually changed their centers when the window for correction was open.
We know the correct number of the students who utilized the minutes reopening of the window, in which 15,000 students utilized the minutes correction model.
No, one second. 15,000 students utilized the window which was kept open for making corrections in their applications.
And we have
now, of the 15,000, how many have corrected the field of the center?
They shy away from.
One second.
Also. Yes.
For them, that they should open this window. Rajasthan High Court
window to correct the fields. The window to correct the fields. How many days was that window kept open?
2 days only.
What are the days?
Well, 9th
and 10th of April.
9th and 10th?
Not for correction. This is not for correction, my lords.
One second. We'll ask them. This is
actually incorrect.
One second, Mr. Kaushik. The window to correct the fields. How many days and when was that?
24. List of dates. On 8th of April,
My lord, sir, page 99 of the paper. 99 correction.
No, don't say.
Now tell us one more thing. The candidate, when the candidate fills in the application form online, does the candidate have to fill in the city or center?
City.
City only. Center is allotted by NTA, by the computer. So what they can change is the city, right?
Yes.
Okay. So if a candidate has, say, filled in Guwahati, that candidate during that window can change it from Guwahati to Lucknow.
Yes.
But no candidate can decide on the center. Is that correct?
Actually,
Centers are allotted only by NTA. Just check, is that correct?
yes.
By computer system or
By the computer system.
Center allotment is only 2 days or 3 days before the minutes exact date of exam. So nobody would come to know which center is going to be allocated.
But that's not an issue. Reflected from center will be the same center.
To correct fields, you are saying?
March 20th to 20th March, page number 98.
Is it correct? 18th March to 20th March?
18th March to 20th March and 11th April to 15th April.
Hold it 1 second.
11th to 15th was additional. New people came in 9th.
And 11th to 15th?
Yes.
It's apparently 9th and 10th. 9th and 10th.
Yes, in 9th and
Now tell us one thing. How many came in, how many corrected their fields between 18th and 20th March?
That minutes data is to be found out.
But you said that 15,000, no?
That is minutes when additional slot was opened on the basis of the court orders and representations. For that time, it was able to make fresh applications.
In April?
Yes, please.
So 15,000?
Yes.
24,000.
Already, 8th April to 15th April, 11th April to 15th April, you said, no?
No, 8th April to 10th April. No.
No.
Correction window is 7th to 15th.
Application was 8th April dated and the window was open for 9th and 10th for new registration. For new registration, not for correction and for correction.
In which?
Sir, I am reading for you from your affidavit and from your document.
What is it?
I was at page number 99.
Just read it.
Page number 99. This is a public notice dated 13th March 2022. The subject is correction in particulars on the online application form of National Eligibility Cum Entrance Exam UG 2024. Now, my lord, I am reading the box, the relevant part. NEET 2024 UG. Duration of correction 18th March to 20th March 2024 up to 11:50 p.m. Field for correction. So he is even not disclosing that what field. It was specifically mentioned that field for correction is as per Annexure A, and that Annexure A was not. Annexure A was filed on the next page. All fields. This is very important.
So between 18th and 20th March, you could correct all fields.
All fields and update documents except the contact mobile number, email. So other than everything has
now,
to be.
which was the second window? We got the first window, 18th to 20th March. What is the second window?
The second window is 9th of April and 10th of April. For 2 days, the second window opened for a new application, a new registration.
At page
that was for 15,000. They will not say that it is, this is unprecedented, it never happened earlier. They say that they were directed to do this by the Rajasthan High Court. Rajasthan High Court order is on record, which pertained to only one candidate. And High Court said, for this candidate, you permit him the registration.
So 9th and 10th April 2024, you said there were 15,000 fresh registrations.
24,000. As per our information.
Now, already asking the question, Mr. Kaushik, now 18th to 20th March 24, how many corrections? That is the window for corrections. Do we have figures about that?
That we will have to look.
All right, and 9th to the 10th of April, how many new applications can?
That according to our information, and we have given the data minutes 15,000 applications. New applications were received.
We take your data, it's official data.
And my lord, one more important
change of center is concerned, the petitioners have focused only at Godhra. In Godhra, the change of center was by only 34 persons, out of which only 16 could be allotted the change of center.
And they are not getting any admission.
They are not getting any.
So, come again, for change of centers.
Yes.
Was by NTA, you changed the center.
By the candidates, by the
permitted change of.
Yes.
No, but you took it that the candidate has no choice of change of center.
Correct.
No, city.
City. I stand corrected.
City.
Right. So,
for example, Jaipur to Gujarat. And out of.
So, do we have any data on how many students all over the country, say the first 1,08,000, we'll now focus on 1,08,000, no better, had changed their cities?
We will get that data, but we have got the data of Godhra only. It's because the Godhra was the only.
So, how many of the 1,08,000 would have changed their cities? We would like to know that.
That will be possible.
And we would also like to see the distribution of which were the cities that they changed. Was there any change in respect of one of these suspect areas, like Hazaribagh or Patna, or is there any concentration in the change of cities to specific cities?
So there is one interesting statistic.
That will give us some idea.
I have seen one.
Is there any skew in respect of those who got registered between the 9th and 10th of April 24? So after lunch, we are just short of lunch. We'll just break for lunch. After all this mental exercise, we also need a little lunch. But what we want to know is this, that those who changed their centers, how many of those have made it to the 1,08,000? That's one. And second, is there any skew in favor of those who had changed the cities on the 9th and 10th?
We have roughly
language. Some people change their language. They said, please give us a Gujarati medium, for instance.
Not language, just that is also language. So, concentrate on 9th and 10th of April. How many students change? How many of the fresh registrations? For fresh registrations also could change their centers?
Yes.
No. Fresh registration date is after which
Can they change the center during that period?
New application is totally different. New applications are completely different.
And an old student.
Asha, one more. Only confined to one student. Then how did you open up the portal for on 9th and 10th of April 2024 beyond that one student? As a result of which 15,000 students registered. Just 1 second, we have something very important. We'll forget it otherwise. Out of the 15,000 students, how many are in the 1,08,000?
Correct. The reason is, I can give.
Mr. Rashik, just talk to your staff at lunch and come back after lunch.
Advocate Nirmala here. I think our discussions are going a little off. My lord, I may be permitted to address your lordship for just 5 minutes.
Of course. Who said no?
No, my lord, before you further proceed, my lord. I was patiently listening everything because I think the whole issue.
One second.
Yes.
One of your colleagues is in.
No, I only want one sentence to be permitted.
After he finishes, we'll hear.
No, my lord, I only wanted to say one sentence. Hear me in one sentence.
One sentence.
One sentence only. The whole question before the court is whether the test should be, examination be cancelled or and a re-examination to be conducted. The discussion is far away from that.
No, this is the heart of it. We have to look at the evidence, the underlying evidence we record to see whether
but that is a major administrative decision. It is not depending on a minor irregularity here or there. It's a major administrative decision. But for a minor irregularity here or there.
All right. Mr. Nedumara, 1 second. We were a little confused. Are you on this side or on that side?
No, I am for the petitioners and my submission is.
You are saying no retest?
No, my lord, absolutely. The only way is to conduct a retest.
Okay. Then and
my lord, I want it's a very soft terminology, very soft terminology. I discussed with the IIT professor, he used a strong terminology. I'm not using it. He used the terminology the professor used was the IIT report. He said, there are 3 types of lies, damn lies, and now IIT report.
Data. Let's not.
No, I'm not using it. I'm not saying that.
Use adjective.
No, I'm not using.
That's not fair. Mr. Nedumara, also 1 second. Let's not just damn it's Premier Institute. It's so easy to say something about a Premier Institute. Give us core facts. Give us core facts.
No, my lord, I'm very soft on them.
Give us core facts.
If I don't want to hear the cold, if I can point out just one aspect of exam, my lord, but if I can just say one aspect before my lord.
All right, we'll come back after lunch. Yes, man. Your Judges Association, I think.
To take.
Today this will go on. So we'll keep pension matter for judges. We'll probably take it up next week. You're safe today. You can.
Grateful, my lords.
Because.
कुछ महत्वपूर्ण डिसीजन जो अभी जो निकल कर के आए हैं उसमें से मैं आपको साझा कर देता हूं कि जो अभी भी जो कुछ पॉइंट्स जो निकल कर आए हैं वहां सबसे बड़ा जो पॉइंट जो मुझे लगा चाहता है भाई कोर्ट जो है वो फैक्ट पे काम करता है। अभी लास्ट में जो पिटिशनर है उन्होंने कहा था कि भाई जो मद्रास आईआईटी ने जो पूरी की पूरी रिपोर्ट दी थी, जो डेटा एनालिसिस किया था वो पूरा झूठा है, लाई है। बट माननीय सीजेजी ने कहा कि नहीं भाई कोर्ट जो है वो फैक्ट पर बात करता है, ऐसे कहने से काम नहीं चलेगा। लेकिन कुछ पॉइंट जो निकल करके आए हैं, महत्वपूर्ण पॉइंट जो निकल के आए हैं वो आपसे साझा कर रहा हूँ और आफ्टर लंच वापस से डिस्कशन होगा, इसी मुद्दे पर चलेगा। क्या पॉइंट निकल करके आए हैं? माननीय सीजेजी ने कहा कि जो सेंटर चेंज करने की जो फैसिलिटी मिलती है विद्यार्थी को, कि भाई जो ऑप्शन मिलते हैं कि भाई जब विंडो ओपन होता है तो ऑप्शन मिलते हैं, तो उसमें 15,000 स्टूडेंट ने अपना सेंटर चेंज करने की डिमांड रखी थी, 15,000 स्टूडेंट ने। तो यहाँ महत्वपूर्ण पॉइंट ये निकल करके आया, उन्होंने पूछा कि भाई जो 1,08,000 जो टोटल सीट है, 1,08,000 में 15,000 स्टूडेंट जो है वो कितने हैं? वो कितने, ये सवाल पूछा है कि भाई वो इसमें कितने हैं। और विंडो ओपन की जब बात की भाई 18-20 मार्च को और 9 से 10 अप्रैल को जो विंडो ओपन हुई थी न्यू एप्लीकेशन और रजिस्ट्रेशन के लिए, तो उसमें कितने विद्यार्थी टोटल थे, तो 15,000 स्टूडेंट का भी कहा गया। तो 15,000 स्टूडेंट का सेंटर जो चेंज हुआ है उसमें से जो, अच्छा ये और सवाल यहाँ पे आया कि हजारीबाग, गोधरा और पटना में किसने लिया था, जो चेंज किया था वो सेंटर चेंज, इन सेंटर पर किसी विद्यार्थियों ने लिया क्या, 15,000 में से कितने स्टूडेंट हैं। और 1,08,000 जो स्टूडेंट हैं वो जो टोटल सीट है इसमें से 15,000 ने कितने इसमें इंक्लूड है, ये जो है। तो इसका अभी तक हुआ नहीं है। अभी आफ्टर लंच उसमें डिसीजन क्या आता है, कैसे आता है, वो हम डिस्कशन करेंगे आपके साथ में। तो अभी हम भी थोड़ा ब्रेक ले लेते हैं, लेकिन बड़ा फैसला है तो सब लोग इंतज़ार हैं, जैसा हम भी कह रहे हैं कि सबको इंतज़ार है, क्योंकि इतनी सारी चीज़ें हैं जिसको लेकर के सब लोग वेट कर रहे हैं। हम भी चुपचाप बैठ करके सुन रहे थे क्योंकि डिसीजन आ नहीं रहा था, तो आप लोगों ने सोचा कि सर कहीं चले गए, कहीं नहीं गया था, मैं ये पे सुन रहा था सारी की सारी चीज़ें। क्या डिसीजन होता है आफ्टर लंच हम भी वापस से मिलते हैं आपसे। थैंक यू सो मच लाइव सेशन अटेंड करने के लिए। और क्या फैसला आता है, विद्यार्थी हित में फैसला है और सुप्रीम कोर्ट जो फैसला देगी सबको मान्य होगा। थैंक यू सो मच, वापस से जुड़ते हैं हम थोड़ी देर में आपके साथ में।